So good afternoon, participants. This is a webinar on the liquidation process, and I would be sharing my experience of liquidation assignments. Today we have with us Mr. Anil Agarwal, who is a chartered accountant based out of Kolkata, and he's a senior partner with AAA Insolvency Professionals LLP. He himself, sitting at Kolkata, is supervising other 6 partners, and he is probably the person who has an exposure of about 23-24 cases that he's supervising while sitting in the Kolkata office of AAA Insolvency Professionals. We also have Ankit Goel, who is a regular panelist with us, and in the morning session he led the webinar on valuation, and where I was participating as handling questions and answering questions. So Ankit also would be doing the same job here, while I did for Ankit, and the Ankit is going to do it for me this night. So the liquidation is a very, very important subject, one that not many they see, like see, when this economy is going for a scenario when the investors may not be many, then there are more and more possibilities of liquidation under this scenario. Whereas I feel that when this valuation will go down, when the transparency will come in the complete, the trust will come in the IBC, then there will be a lot more investors which will come. The money that people are having with them, and that money is not bringing those kind of returns. The ROI on FDR, ROI on the rental is declining. So everyone would like to look for some business where they can get better return of investment. So the time that is going to come in 1 year's time, I believe there will be a lot of people who would be interested in taking over companies under insolvency or under liquidation, because under liquidation also the companies can be taken over as a going concern. So today's webinar is a complete subject of liquidation process, along with the various latest judgments on liquidation process, also on various hurdles that we have faced in our experience. As AAA Insolvency, we have a total experience of 35 liquidation assignments, and this 35 liquidation assignments are a big experience, and that too amongst 42 partners. Everyone is working together using the same team. So we have different teams under insolvency and bankruptcy. So one of the team is the liquidation team, and then asset sale team, then the resolution plan facilitation team. So there are many such teams that are working, so that those experiences all would be added to this webinar. Besides this, we also have the experience of handling about 27,000 SARFAESI cases, where our scope of work is to take over the property and find a buyer and sell it. So that experience is also adding to our success in the insolvency and bankruptcy. See, while I'm saying so, the contents, while I was preparing the contents, I saw that there's many things and many questions are going to come. So the format of the webinar again would be same. We have Mr. Ankit Goel and we have Mr. Anil Agarwal. They would both be taking questions and also trying to track questions. And every 30 minutes, we will have a break for question answer session. And please do ask your questions on question and answer part panel, and don't write your question on chat, because see, the questions would be taken from a Q&A panel. So that would be the right place where you can place your questions, and Ankit and Anil Agarwalji, they will take up the questions from time to time. So I'll start now with my presentation, and if I can share my screen, I will. I think you have to just.
I will do that.
Yeah.
I have done. I have changed. I have changed the settings. Now you'll be able to share the screen.
Yes. Okay. So, as I said, the liquidation process for the corporate debtor, that's what is the subject today. And like whenever we start thinking about liquidation, maybe whatever is the value of the asset, whatever is the beauty of the asset, you would see no life. The picture that I have placed on my presentation would explain that despite the beauty, the liquidation means low life. So we would not like to have this kind of scenario in the country, wherever the asset is having some beauty, some life, some viability possibilities, some revival possibilities. We will try to revive that business, and we will not leave that a business as a still business, as a closed business, because the closed business would not add anything. So see, like, first of all, I would say that there used to be something like called winding up proceedings and or under the Companies Act, where the official liquidator used to be appointed. Now that process is almost a sunset process, and the only option for liquidating a company is either through the voluntary liquidation or through the IBC. And there is no direct route to liquidation process. One has to go through the corporate insolvency resolution process. So this is a two-stage process: first CIRP, and then liquidation in case there is no revival, in case there is no takeover possible. So scenario, see, after this insolvency and bankruptcy is that anyone who would like to go for liquidating the company would like to, in case the company is having capacity to pay all its debt, in case the company is having capacity to pay all its debt, then the company would go through the voluntary liquidation process. And in case the company is not able to pay all its debt, then the company would be required to file an application under section 7, 9 or 10 and go through the CIRP process. And in case there is no resolution applicant, in case there is no resolution plan approved, then this company would go for liquidation process. In the liquidation process, the liquidator would be appointed. So in a present scenario, if we have to ask one question, like who can order for liquidation, who can order for liquidation, and the only order now which can come for the liquidation is National Company Law Tribunal. NCLT can only pass an order for liquidation. So what are the circumstances under which the liquidation order can be passed? One circumstance that we all understand, see, I am not sure about the composition of my audience. I understand that the committee of creditors, like the bankers and the financial institutions, would be there. I also understand that the resolution professionals would be there, and maybe that there are many people who would like to, who are learning insolvency, those also would be there. So the under one section 33 subsection 1 and subclause A, if NCLT does not receive a resolution plan within the CIRP period, maybe 180 days or maybe 270 days or even further extended period of 330 days, or any period which is excluded or extended after that, in case the NCLT does not receive a resolution plan, then the company would be liquidated. So in such scenario, when there is no resolution, then it becomes the duty of the RP to file a report before NCLT along with an application that no resolution plan could be seen in this case, could not be received, so the company may be liquidated. So this is a one scenario. So the second scenario is that the NCLT rejects the resolution plan under section 31 for non-compliances of the requirement as mentioned in 33(1)(b). So in case a resolution plan is submitted to NCLT and it is not approved by NCLT, then the company would also go for liquidation process. When the RP at any time during CIRP, but before the confirmation of resolution plan, intimates NCLT of the decision, so the committee of creditors can also take a decision for liquidating the company after understanding that the company doesn't have any possibility of revival, therefore should be liquidated. So that is also a third reason for liquidating a company, or the company will go for liquidation. See, when a resolution plan is approved by the NCLT and is contravened by the concerned corporate debtor, any person other than the corporate debtor whose interests are prejudicially affected by such contravention may make an application to NCLT for a liquidation. So this scenario is when a resolution plan is approved by the NCLT and the resolution plan could not be implemented in total. So
there are some requests to speak a little louder. So maybe we can maybe adjust the
one
mic.
that I have seen, there is a possibility of increasing the volume of your speaker on your device. Maybe it is a phone or maybe it's a laptop or a desktop. There is a possibility of increasing the volume. So in the morning session also, I saw that some people were saying that the volume is not okay. Some people were saying it is okay. Then I realized that it may be only because of your own speaker volume, which might be at low at this moment. So kindly try that. I will also try to speak a little louder. So in case a resolution plan is not implemented, then also on an application by any person whose interest is prejudicially affected can make an application to NCLT, and NCLT may pass an order for liquidation of the company. So these are the various scenario where the company can be liquidated. So there was an NCLT judgment, and that NCLT judgment was basically attending to a scenario that the NCLT said that the companies should not be sent to liquidation so early. We have experienced that the NCLT was sending some of the liquidation applications back to RP, asking the RP to explore further possibilities for a resolution plan. So based on this feedback, the law was amended with effect from 16th of August 2019, and in section 33 subsection 2 an explanation was added, and the explanation which was added reads as under: for the purpose of this subsection, it is hereby declared that the committee of creditor may take the decision to liquidate the corporate debtor at any time after its constitution under subsection 1 of section 21 and before the confirmation of the resolution plan, including at any time before the preparation of information memorandum. That means that the committee of creditor is constituted and the committee of creditor has seen that there is no possibility of revival. So the committee of creditors can decide immediately that the company may be liquidated. By way of this amendment dated 16th of August 2019, this amendment was effective. So based on this, the intention of the legislature is that in the company, in case there is a rationale to liquidate the company. So in certain cases, I would say that there are so many cases so far. In the case of VIP Finvest Consultancy Private Limited versus Bhupan Electronics, it was held that it is prudent for the company to go for a liquidation, as the company had not been operational for decades and had no employee on its payroll. Further, there was a judgment in the case of Sivas Trading Private Limited versus Abhayam Trading Limited. It is NCLT Chennai judgment, wherein the corporate debtor was liquidated as there was lack of business opportunity and the creditors felt there was no point putting good money to recover bad money. Best Deal TV Private Limited, NCLT Mumbai, the committee of creditors recommended liquidation since the business activity were already closed down and all the employees had left the corporate debtor. SK Motors Limited again said the same thing, as the resolution professional did not invite bids from the interested parties. However, the committee of creditors noted that inviting bids would only prolong the process of resolution and would not yield any result, as a corporate debtor was not a going concern. So when we understand the rationales, so the rationales for pushing a company to liquidation can be like there are old and dead cases where the insolvency revival is very, very remote. Liquidation is the only natural outcome. In case of highly stressed businesses, the liquidation may be a valid commercial outcome. So all these rationales can also include that there is no business prospects with the company, there is no substance in chasing the legal suits and cases for recovery. There is no point in spending money to make efforts to recover bad money, having very remote chance of recovery. So all these rationales, in case we see and then decide about liquidating the company, all the benches would agree. And even we have experienced that within the immediately after the constitution of COC, the very first resolution that we have passed is to liquidate the company, as we could see there was no asset, we could see there is no business, and even there is no possibility of even recovering the cost of CIRP. So therefore, wherever there is no business, wherever there is no feasible business, all this should lead to the liquidating the company decision. So once the liquidation order is passed by NCLT, there are some immediate effects. And the most important immediate effect is again section 33(5), which is again a kind of moratorium. And in this moratorium and the moratorium that we see in section 14 of CIRP, that section and this section, there is a difference. In this case, it is mentioned, no suit or other legal proceedings shall be instituted by or against the corporate debtor. Whereas in the case of CIRP, it is written that no suit or legal proceeding shall be instituted or continued. So here the word continued is missing, provided that the but that's a very big impact for just missing, just removing one line or one word, that continuation of existing proceedings. Now once the liquidation order is passed, most of the litigation or proceedings or suits which were kept in abeyance during CIRP would restart, and all the proceedings will restart, including the arbitration proceedings, tax proceedings, everything will restart during the liquidation also. However, there is no possibility of any coercive action or attachment or recovery during liquidation. However, all those proceedings where either the assets of the company are being chased or somebody else is chasing to finally arrive at a figure of claim. So the many arbitration proceedings where the dispute is dispute was kept in abeyance during CIRP. So immediately after the CIRP, in the liquidation process, the dispute would be restarted, the proceedings would restart, and even if it's arbitral or if it is any other tribunal or any other court or authority, that would restart to finally assess the value of the claim. Even the liquidator is also not allowed to file any suit against other companies or other people unless the approval of the adjudicating authority is given. The liquidation order immediately would be considered as a discharge for the employees and officers and workmen of the corporate debtor, except when the business of the company is kept as a going concern. If the business of the company is kept as a going concern, then it would be the prerogative of the liquidator to keep and retain some of the employees who are actually working for the company to keep it as a going concern. All the powers of the board of directors or key managerial personnel all would immediately come to a standstill, and the liquidator would be the complete in charge of the liquidation process. Liquidator would be the complete in charge of the company, even the operations of the company, assets of the company, any recoveries that the liquidator has to make, that all would be done by the liquidator. So once the liquidator is appointed, in most of the cases, the liquidator would be the resolution professional who handled the CIRP. But however, there are now the changes are happening. There are many judgments in the from the NCLT and NCLAT where the RP is not appointed as the liquidator. So that one scenario that we will discuss in the subsequent slides, that how it is possible that the RP is not appointed as a liquidator. So NCLT shall by an order replace the resolution professional also in certain cases. For example, the resolution plan submitted by the RP is rejected for failure to meet the mandatory requirements of the resolution plan, then the NCLT will not appoint the RP as a kind of a penalty. Then the NCLT will appoint somebody else. Earlier they were taking the name from IBBI. Now they are picking up a name from the panel which is maintained by IBBI and sent to NCLTs every 6 months. Now the name of the IP is picked up from that panel. So it's like the liquidator, of course, the appointment of the liquidator as the eligibility is concerned. The eligibility is all knows that any person, the person has to be independent. Anyone who is able to be appointed as RP can be appointed as a liquidator. So that's not something that we will discuss at length. Even for the fee of the liquidator, we have a better analysis in the subsequent slides. Now, the concept that at this point of time I would like to attend, can a COC appoint a liquidator other than RP? So we have some experiences in this case, because the very first case was Keshav Sponge and Energy Private Limited. In that case, the COC tried to replace the RP in the 7th month of CIRP. Then the NCLT rejected that application, saying that it is not appropriate that I change the RP in the 8th month, because by the time the application came for hearing, it was 8th month, and those days it was not kind of exclusions and extensions were not very popular. So he thought that the bench thought that it is only 1 month and we should not change the RP. So they rejected. Then we guided the COC that you pass a resolution for liquidating the company, and in that resolution you also opt for a liquidator. So that was the first time in country in the case of Keshav Sponge and Energy Private Limited, and that was a Kolkata bench order where the COC preferred another IP as a liquidator, and the RP also was willing to continue as a liquidator. In that case, the COC, whatever was decided by the COC was accepted by the bench, and the IP which is selected by the COC was appointed as a liquidator. So there are other cases also, like Sandeep Kumar Gupta versus Steward and Lloyds of India Limited, where the NCLT in fact changed the RP and the liquidator was appointed other than RP. In the case of Devendra Padamchand Jain, a resolution professional versus State Bank of India, the adjudicating authority it was decided by NCLAT that the adjudicating authority has the power to appoint or replace the RP. See, but most of the cases I have seen now that once the COC is deciding, once the COC decides that we should have a different liquidator and we should not have RP to continue as a liquidator, then the COC has many ways to do it. One way is that the liquidator's fee has to be decided by the COC. Once the COC decides to liquidate the company, the fee of the liquidator has to be decided. So at the time of negotiation of fee, the COC can say that yes, we are having better offers in the market, so we would like to go for the better offers. So that also can be used as a power to appoint a different liquidator rather than the RP to continue as a liquidator. And most of the COC, in fact, are doing this nowadays. I would be very happy to say that we have been appointed as a liquidator, whereas we were not the RP in many cases. So few of the prominent cases that I would like to say is the Nirav Modi companies. In the Nirav Modi companies, we have been appointed as a liquidator and we were not the RP. Similarly, in the case of Gitanjali Group, Merul Choksi Group, in all their 3 companies, we have been appointed, our consent has been submitted to NCLT for appointment as liquidator. In the case of Vikram Kothari, we are already liquidator. And in the case of Junjunwala Group, like REI Agro and Varsana Ispat, we are also a liquidator as of now. In many other cases, we have been appointed. Maybe there are about 15 cases with us presently where we were not RP and we have been appointed as a liquidator by the committee of creditors. So see, the scenario is changing nowadays. Like every member of COC started thinking that the liquidation is a different profession and the resolution professional is a different professional, is a different profession. Both needs a different kind of infrastructure and different kind of capabilities. So the COC is also taking a decision, and primarily is also like fee negotiation is a very big tool with them. And also once the COC says to an RP that we would like to change, then RP also in most of the time RP is not interested and RP will not give the consent. So with this scenario, we have about 15 cases where we have been appointed as the liquidator where we were not the RP. So see, the scenario is, as I said, is changing in a very fast way. Another very, very important part that we have seen very recently is in a 21st January 2020 judgment, that is in the case of Punjab National Bank versus Mr. Kiran Shah, liquidator of ORG Informatics Limited. So in this case, the Punjab National Bank filed an application for liquidating the company, and the NCLT appointed the liquidator, appointed the RP as the liquidator. At the time of application, at the time of passing the liquidation order, NCLT had no information whether the COC was interested the RP to continue or not. So when the application was filed by the RP also submitted their her consent, his consent. But later on, the Punjab National Bank decided to file an appeal, and in that appeal, the NCLAT rejected. It said that in the CIRP of ORG Informatic Limited, the COC of which PNB is the lead bank, decided to move an application for liquidating the corporator. The said application has been accepted by the adjudicating authority, Ahmedabad bench, by impugned order dated 20th of November 19. The resolution professional has been asked to continue as liquidator. Appeal filed against the appointment of liquidator. See, while dismissing the appeal, it was held by NCLAT that after the liquidation, the committee of creditors has no role to play, and they are simply a claimant whose matters are to be determined by the liquidator, and cannot move an application for removal of liquidator in the absence of any provisions under the law. So what is important here to understand is that there is no provision under the law to remove a liquidator. There is only one provision, that the person should file a complaint to IBBI, and IBBI will investigate into that complaint. And in case IBBI finds that the complaint is complaint is genuine, then IBBI will recommend change of a liquidator and would recommend another party. That's what is written in the law. But the COC cannot decide after the liquidation order is passed to change a liquidator. So this is very, very clear. So in case the COC has any mind of changing the liquidator, it should actually be done at this stage of CIRP while the application is being filed, or even before the liquidation resolution. The RP can be changed in the 7th month or 8th month. But the most appropriate method would be that the liquidator should be appointed, and the earlier resolution professional should not be giving their consent. Even otherwise, in case the COC passes an order, passes a resolution for appointment of any other person as liquidator, along with the resolution to liquidate the company, that would be honored by the NCLT. That's what we have seen in a couple of cases.
I think we can take some.
I think we can.
Yeah. So one of the questions just now came in was from Mr. Rasik Singhania. He's asking that he's been appointed as a liquidator in a recent case, and all the CDs, and the company was doing a multiple banking, and all the CDs have taken away the assets from the IBC process by enforcing their security interest, and the liquidator hardly has any assets in the common pool, and he has not received any fees till date. What is your recommended course of action for him?
No, I think section 52 is one section which is available for the secured creditors to invoke. So if they invoke section 52, that means that they are not relinquishing their security interest in favor of the liquidation estate, and they would like to sell their assets themselves. So this is also a unique scenario. In our case, we haven't seen such scenario because we have assured that the distribution of the proceeds of sale of assets would be done as per the priority of charges, like the first charge, second charge, third charge. So in case anyone having any misunderstanding about the distribution of proceeds of assets on a pari passu kind of ratio, then everyone will take it away. So this is a very, very important part of my presentation today, that the distribution of assets under a liquidation process would be as per the priority charges: first charge, second charge, subservient charge, special charge. Everything would be honored during the liquidation process. And if somebody has given a car loan, and if I, as a liquidator, tell that person that I will sell your car and I will allocate the assets to all the creditors, then that car lender would immediately invoke section 52 and take away the car. In case we give comfort to them, and the comfort would be such that anyone having any specific charge on any asset, the proceeds of sale of that asset would first be going to that person, and in case there is anything remaining, that will go to the other secured creditors. That assurance has to be given by the liquidator. I have given in my practice, I have even given in writing this kind of assurance to many committee of creditors members, because they were apprehensive whether the liquidator will allocate pari passu or not. So we gave them the rationale, we gave them the law that we believe on, we gave them the interpretation that we believe on, and we wrote them 3-4 page letter and assured that whenever I will sell this asset, it would be allocated to you. Then in all these 35 assignments of liquidation, we have not seen even one instance of invocation of section 52 of the IBC. So this is very, very important question that you have taken, Ankit.
So in this case, where the FCs have decided to take the assets away, I don't think the liquidator has any option but to approach the NCLT and
no, the liquidator, first and foremost is that the liquidator has to take control and custody of all the assets. Then the liquidator will see the regulation 37 of the liquidation process regulation and also section 52 of the IBC. In both these section and regulation, it is very clearly written that all those creditors, secured creditors who are not relinquishing, the liquidator will only hand over the asset to them after recovering the liquidation cost and the workman dues. After recovering the liquidation cost and the workman dues, because everyone knows that the workmen and the secured creditors are ranked pari passu while distributing the assets. So the workman dues and the first priority would be the liquidation cost that has to be recovered from all those secured creditors before handing over the asset to them. So the liquidator was supposed to work in this manner, so that the whenever you would display the section 52 and regulation 37, it would be very, very clear to everyone that they would not be able to take away the asset till the time they give the liquidation cost and the CIRP cost to the liquidator in case it is unpaid.
So a lot of questions about the fee of the liquidator and basically
the fee of the liquidator, I have a complete chapter, so I will not like to answer that now because I have a complete chapter on liquidator's fee.
Then moratorium, that when the moratorium ends at the end of CIRP, so the questions are related to what will start again, what proceedings will start again, and what to do about them, how to deal with them.
I think as I said, already I answered this question in my first 5 minutes, that there is a difference between the moratorium during CIRP and moratorium during liquidation. During CIRP, the institution of new suits and continuation of the existing suits proceedings would be kept in abeyance. Whereas in liquidation, it is only the institution of new suits. So the continuation of existing suits or proceedings is missing. So therefore, once the liquidation order is passed, all the existing pending proceedings, maybe tax proceedings or arbitration proceedings or court proceedings, would continue and it would start. And some of the proceedings would be filed by the company and some of the proceedings would be filed by the others. In some of the cases, there would be an asset, and some of the cases, there would be a liability. So that has to be handled by the liquidator. In case this is a case where there is an asset is involved, then the liquidator should definitely look into the litigation and try to preserve the asset and try to maximize the asset by fighting that litigation. In case it is for the liability, then the liquidator would assess whether that person's liability is an operational creditor or it's a secured creditor. So based on the priority and based on the liquidation value, the liquidator will decide whether to take up that case seriously or simply surrendering that in the court, and whatever claim comes, that claims can be admitted, and finally the distribution can be made as per section 53. So for example, I was handling one case where there was a claim of 1,100 crore. It was an arbitration case. So immediately after the liquidation, the arbitration restarted. And in the very first hearing, I said that I'm not interested in continuation of this arbitration, because even if I lose the entire, even if I had to admit complete 1,100 crore claim, it would be an operational creditor. And in my case, I'm not even having 25% for the secured creditors. So it is not impacting me. I would not like to waste my time and money and resources on this arbitration cases. So then finally, I thought that it should be closed. So in fact, I closed that. So this is the example that I'm trying to give you. This is the reason. If similarly for the tax proceedings, unless the recovery, because as far as the coercive recovery is concerned, nobody can do coercive recovery during liquidation process. It is only the proceedings will restart. Assessment proceedings, appeal proceedings will restart. So we will have to attend to these proceedings depending upon our perception of assets and liabilities into that litigation. In case there is an asset into that litigation, we should definitely try to maximize the value. In case there is a liability, then we should understand the liability value and the liquidation value of the company and what is the priority under section 53 for this claim. So based on this, the liquidator will take a decision whether to how much importance has to be given to each suit or each proceedings. So Ankit, is there any other question which we should take up now? Because
I think you can continue, and then I will take up questions as and when they are related to the subject that you're talking about.
Okay, this see like the powers of the liquidator. Like I think I should again say in this when we have most of the participants presently, I must say that the presentation is very large and I don't want to force close. I would continue the way I'm going, and I would try to answer some questions also in between. In case I would not be able to finish in 2.5 hours maximum, because otherwise it might even get boring, then we will have the part 2, and we'll have the part 2 on the next Sunday at the same time, and the link would be sent to all the participants again. So I'm also presently thinking that it is not possible really to go through the entire liquidation process in 2.5 hours, and that too with the latest judgments, and that too with the latest amendments. And that also would add my own experience of 35 cases and also SARFAESI experience. It will also discuss about the infrastructure what is required for liquidation assignment. The liquidator is also supposed to take custody and control of all the assets, also to evaluate the assets of the company. The liquidator is under responsibility to protect and preserve the assets, to carry on the business in case there is a operational continuation. So this is called beneficial liquidation under subsection E to section 35, to carry on the business of the corporate debtor for its beneficial liquidation as it considered that. So what is beneficial liquidation? Beneficial liquidation is like the liquidator starts thinking, or the COC thinks, that in case the company is kept as a going concern, it will be beneficial. Then this is called beneficial liquidation, where the company's business would continue. In fact, practically, I'm actually continuing with a business with a company, and that company is doing a turnover of 1,000 crore every year, almost 80-90 crores per month. That's a steel plant, and that plant is running under liquidation. For the last about 9 months, it is running under liquidation. See, why we are not able to sell it? Because all the assets are attached under PMLA, whereas the plant is actually working and it is earning profits. So this is the way we are handling liquidation. And once this detachment will happen, since now the 32A section has been inserted, and after 32A, the lockdown started and our application is not being heard. Once the application would be heard, the detachment will happen, then we will sell this company as a going concern. We will transfer the company as such, along with the name. And this would be a very, very unique case of sale of a company as a going concern during liquidation process. The liquidator is also empowered to sell the immovable properties, movable properties, actionable claims, and the bank account would be opened by the liquidator. The liquidator will do everything in his own name as administrator, as normally as an owner would have done it. So the liquidator position is a very, very powerful position. Earlier, there was nothing like COC. For a CIRP process, there is a committee of creditors, and the committee of creditors mostly take the decision. However, in the case of liquidation process, there is a stakeholders consultation committee, which is also with effect from July 2019. Earlier, there was nothing like this, and the liquidator was completely independently handling. However, the secured creditors, in fact, they represented before government that this is becoming too, the liquidator is working in isolation and not even providing much of the information. So the scenario was worked out in such a manner that the liquidator would actually provide information to the creditors. The liquidator can even have appoint professional assistance in discharging his duties. And this also includes, because I will have a coverage on the whether the brokers can be appointed for the sale of assets or not. The liquidator can invite and settle the creditor's claim and institute or defend any suit. The liquidator will recover money from the sundry debtors, advances, claims, refunds, insurance claims. Every part of the recovery is also supposed to be done by the liquidator. So in case we divide the powers, divide the jobs of the liquidator, let us first of all is the custody, control, preservation, and protection of the assets of the company, number one. Number two, handle all the litigations, proceedings, assessments during the liquidation process. Number three, to get all the claims from the creditors and try to settle those claims by way of sale of assets. Four, in case it's a company which is a going concern, then to run the company and to do it as if an owner is doing the entire business. So whenever there is a difficulty, the liquidator can also file an application to the adjudicating authority for such orders and directions as will be necessary to form. See, so this is what is the various functions of the and various powers of the liquidator. So immediately after the announcement, the liquidator is supposed to make a public announcement within 5 days, and the claims would be invited, which is the 30 days are given for the claims. The public announcement would be done in one in English and one in regional language. It will be at the registered office of the company or even the principal office of the company or any material business place, on the website of the company and on the website of the IBBI. Then the stakeholders will file claim based on the invitation and the public announcement. The stakeholders will actually file a claim, and that would be a fresh claim as on the LCD's liquidation commencement date. So I would use the LCD as liquidation commencement date. The claim, there are two options. One, that the stakeholders can file a fresh claim, and there is a second option. If somebody has already filed a claim under CIRP, so he can only update the claim rather than sending all of the documents again. He can only say that I'm adding the interest or I'm adding the transactions during the CIRP. Rest everything can be used as already available with the RP. So in the all these claims and the liquidator will maintain a register of claims and also whatever dividend is paid by the liquidator. Now, I think this is a very, very preliminary, but it is very, very important to understand what are the claims during liquidation process. And in case we read carefully, and there are some words that I would like to highlight. The definition of word claim is given under section 3, subsection 6 of the IBC, and it means a right to payment. A right to payment, whether or not such right is reduced to judgment. So that means whether there is a judgment, court judgment, arbitration judgment or not, that doesn't matter. Fixed, disputed, even the word disputed is also written. Even if the claim is disputed, the claim has to be filed by the stakeholders. Undisputed, legal, equitable, secured or unsecured. So I wanted to highlight the word disputed because the definition of the claim is that even if it is a disputed claim, the liquidator will have to take that claim, and then I will touch upon it, how this liquidator will handle the disputed claims in my subsequent slides. So the second part of the definition is right to remedy for breach of contract under any law for the time being in force, if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured is a copy of all these words. However, what it says is that on a breach of a contract, if there is any claim that I feel is recoverable from the company, that can be filed. And even if the amount is not determined, even if the amount is contingent on some other facts, still, if there is a contract and if there is a breach of contract and if there is a claim based on that breach of contract, that has to be filed irrespective of the fact that it is matured, unmatured, disputed. So there are two new words that we have seen is matured, unmatured, which was not there in the first row. When we say matured, unmatured. Now, let's take an example that if a company is given to public, or the company had come out in the past something like deep discount bond. Now, the deep discount bond, in case for an illustration, the company issued deep discount bond in 2015, and the deep discount bonds are supposed to be matured along with the interest in 2025. So if I'm presently handling the liquidation of that company, that means that the payment of that particular deep discount bond is not due. Those bonds are not matured. Those are unmatured. Still, I will file my claim. Because it is not depending upon whether the payment is due or not. Secondly, if I have supplied goods to another company, and as per the supply of the goods, I am supposed to get my payment on after 90 days. However, within 30 days of this supply, the company goes into liquidation, and I have to file my claim, and nobody can say that even my payment is not due for payment. So these are 2-3 words which I have to explain to you. This is very, very important. Section 18, subsection B also talks about the duty of the IRP to receive and collate all the claims. And that's what is during CIRP, because section 18B is for CIRP, submitted by the creditors to him pursuant to public announcement. Section 25(2)E, which is for RP, the duty of the RP to maintain an updated list of claims. So these two lines are for the CIRP, and let us see what are the duties of the and powers of the liquidator under liquidation. Under liquidation, we refer to section 35(1)A and powers and duties of the liquidator to verify claims of all the creditors. So when we verify, and then the word there written in the section 18B is to receive and collate. Now, during liquidation, the claims has to be verified, whereas during CIRP, the claim has to be collated, of course, with some kind of verification also. But during liquidation, the verification has to be complete. The 35(1)J, powers of the duties of the liquidator to invite, settle. So this is okay. So the basic difference between CIRP and liquidation is that the CIRP is a collation, whereas in liquidation it is verification of the claim. Now, for the purpose of verification of the claim, the liquidator has actually been given very vast powers. And it is very important for us to read section 37(1), where the liquidator actually is given in power for the purpose of admission and proof of the claims, and also for the purpose of identification of the assets that the liquidator can access. An information utility, a credit information system regulated under any law for the time being in force, maybe civil or maybe any credit system, any agency of the central state government and including the registration authority. So as a liquidator, I can even write to the income tax department or to the state tax department or to the registration authority to know about the assets and to know about the liabilities of any company. So this is the power of the liquidator to seek information from the following sources. Information system for the financial and non-financial liabilities regulated under any law for the time being in force. That may be even RBI is concerned. The information system for securities and assets posted as security interest regulated under any of the time being in force, like this means CERSEI. This means CERSEI. Any database maintained by the board, any other source as may be specified by the board, and the board has not actually specified anything like this. Now we start another section which is talking about the claims to be received from the liquidator, and the claims would be, I would not spend much time on the claims part of it because this is considered which is elementary. So the claims by the financial creditors will be filed in Form D. The only thing I want to highlight is that there is mostly a confusion that whenever we receive claims during liquidation process, most of the creditors are in fact using the CIRP forms, whereas the CIRP forms are different and the liquidation forms are different. In liquidation, we are using the forms which are given in the liquidation process regulations, whereas in CIRP, we are using the forms which are given in CIRP regulations. So in liquidation process, Form D is provided in Schedule 2, and that is from the financial creditors. And it is very important to notice that the financial creditors are supposed to submit their claim only by electronic means. Only by electronic means. So this is a very, very important difference between the claims to be submitted by operational creditor, workmen and employees, and by the financial creditor. May be secured or unsecured, but all the financial creditors are supposed to file their claim in electronic mails. See, all these are the documents which are supposed to be submitted along with the proof of existence of the debt. The last line is very important, that in case the loan has been given against a bill of exchange, promissory note, or other negotiable instruments or security of like nature, then these documents shall be produced before the liquidator. Because the bill of exchange or a promissory note or a hundi, these are the original documents which are negotiable instruments. Now these negotiable instruments has to be presented in original before the liquidator for the claim to be admitted by the liquidator. See, the other part is the claim by the operational creditor. The form is C, and the only difference is the operational creditors, other than workmen and employees, can come in person. They can send by post, or they can even send by electronic means all their claims. These documents are there which are supposed to be attached. And the important part of the operational creditor is that the financial accounts of the operational creditors are also supposed to be attached for submission of a claim. And what we feel that the evidence of supply of goods and the invoice, everything has to be given along with the financial accounts. The claim by the workman and employee, that also is to be filed in a Form E, and that is also possible to be filed in person, by post, or electronic means. So, but in case there are numerous employees and all the employees want to file their claims through a authorized representative, then they are supposed to file the Form F, not Form E. One important difference is, besides the document that they are supposed to attach, and very, very important difference is, the liquidator may admit claims on the basis of books of account of the corporate debtor if such workman or employee has not made a claim. So the employees, even if they are not making claims, books of account of the company would provide us the information as an RP to admit their claims without even a claim being filed. So the liquidator will have to admit their claims based on the books of account, irrespective whether the workmen or the employees have filed their claims or not. This is very, very important. There's something which is important is the workmen and employees. So Ankit, is there any question regarding the employees dues?
So the first a few questions. So I think you've already answered this question, that what if a party is a creditor in the balance sheet but does not submit claim?
Yeah.
Then will his claim still be stand and considered?
As far as the employees is
Is this,
concerned, there is a
yeah?
special reference, but
But
as such in the operational
otherwise
side,
it will not be.
otherwise it's not there.
And then we have a question, that is the declaration of the claim supposed to be notarized?
I mean, earlier there was a requirement. I don't think there is a requirement now, but that has to be looked into the form, because at the bottom of the form, the latest form that is there in the regulations, that has to be seen. And in case it is required, then it is mentioned in the bottom of the form what kind of stamp paper is required or what kind of affidavit is required. It has to be, it is mentioned there. But see,
Okay.
presently it is not really required to be notarized. If affidavit is there, anyway, I think it is mentioned there whether it is required to be notified or not.
Then there are questions on so in response to the public announcement by liquidator, no claims were filed, not even by those who had earlier filed in case of CIRP. What should be done? Should the public announcement be issued again?
No public announcement is not required to be issued again. See, the only thing that the duty of the liquidator is to see the books of account, and in case there are genuine claimants and they might have skipped the public information, then those people should be touched. Those people should be informed so that they file their claim. And in case the company doesn't have any asset also, and the company doesn't have any claim, after waiting for some time, after looking into the financial position, the financial statements, and after talking to the directors and the COC members, in case the liquidator is convinced that there is no asset and there is no claimant, then the application should be made for the dissolution of the company.
Okay. Then we have a question from Reshma Mittal saying that whether fresh filing of claim is compulsory. I think yes. I think you have to furnish a fresh claim even if you have furnished a claim during the CRP process.
No, I said I already ordered.
Yeah.
I already said that. I'll again go back to the same slide. I said on 25th of July 2019 there was an amendment. On 25th of July 2019 there was an amendment, and now it is provided in the amendment that even the claims can be updated, or even somebody can say that my claim is same as I filed during CIRP. So he's not supposed to file this
Okay.
claim
So the
entirely again.
refiling is not required. Okay.
Refiling is not required. You can even update. You can also refile it in case there is a change. But once it is admitted, and most of the people have started adopting the updation part, because the banks are only saying that you add the interest for this period, there is no other transaction.
So basically you're saying that the claims have to be updated till the date of the liquidation order. So basically the time period changes, that if you during CIRP your claim was as on the CIRP date, in case of liquidation it is on the date of the liquidation. So that changes that might have a change in the claim amount.
Absolutely, absolutely.
And apart from that, let me see if we have any other questions. So what if the liquidator does not have any access to books of accounts? How do you verify the claims?
No, see, first of all, the liquidator only will come once the RP is there. So what liquidator is trying to say now is that the RP could not get the books of account. So the RP also didn't have the books of account. That means that the RP must have made all the efforts of getting the books of account, and RP also could not make any books of account. So this is practically very difficult, because the RP in any case is supposed to make books of account. And in case the RP is also not able to make any books of account, then the liquidator will also not have any proof that whether there is any liability in the company books or not. So the liquidator will also depend upon the claims only.
Okay.
So in case the books of accounts are not there, the liquidator can't do anything. So he will do as per the information available and according to the information available.
Then we have a question that from Koshai Puri, that can a financial creditor revise his claim filed with the liquidator?
Yes, the claim is revised, because I have a full slide on that, how the claims can be revised, and how the list of stakeholders can be modified, and how the application can be made to the adjudicating authority for modification of the list of stakeholders. I will come to that slide. Be with us.
Any time limit to file the claim?
So the time limit of 30 days is given, but beyond even beyond this, if somebody is coming and filing their claim, I don't think there is any reason to reject that, because they are all stakeholders. and those stakeholders, the claim keeps coming, and the liquidator is supposed to admit all that. However, the stakeholders consultation committee which is being constituted, that may not change. And I'm also saying, but because a lot of people, they are coming late again and again, so we are trying to say that it costs, because in case somebody is delaying, then it costs, because the list of stakeholders has to be made afresh. The list of stakeholders has to be submitted to the NCLT. You would have to hire a lawyer. So anyone who is coming for the delayed submission, the liquidator can ask from him that this is the cost that we are incurring for getting the list of stakeholders modified. And in case he is very keen, then all this cost should be charged from him who is coming late, because we have already published our list of stakeholders.
So I think there are a lot of questions. We have about 170 questions. So it's difficult to answer all those. I think we can continue and then we can start questions, take some questions again after half an hour.
Now I'm coming to a very important order of NFLAT, that is in the case of Mr. Savan Godiwala, in the case of Lanco Infratech Limited, and that is versus Mr. Apala Siva Kumar. So in this case, it was again a dispute like State Bank of India versus Moser Bear Karamchari Union, and that order was passed by NFLAT in March 2019, where it was held that the all sum dues to any workmen or employees from the Provident Fund, Pension Fund, and Gratuity Fund do not form part of the liquidation estate or the liquidation assets of the corporator. It was held that the Provident Fund dues, Pension Fund dues, and Gratuity Fund dues cannot be part of 53 of the code and has to be given on priority over and above section 53 of IBC. Now this judgment, which is 11th February 2020, which is Savan Godiwala in the case of Lanco Infratech, in this case it was very clearly held that there was no provident fund, there was no pension fund, and there was no gratuity fund in the books of account, and there was no money in these funds ever available. However, on the other side of the balance sheet, there was provident fund dues, and also there was gratuity provisions. So the gratuity provisions which was made and the provident fund dues which were there, those were not considered to be provident fund, pension fund, or gratuity fund. According to my understanding, also the provident fund, pension fund, and the gratuity fund are those funds which are maintained by the company in the same balance sheet as a separate cost center, and the money is being collected from the workmen, and is also contribution is made by the employer, and the investment is done within the company, and those funds are earmarked for the specific purpose such as provident fund, pension fund, and gratuity fund. So in none of these cases, like neither Moser Bear or nor Lanco Infratech, there was no such fund in the financial statements or balance sheet of the company. However, in the Moser Bear case, there was an order that all these gratuity fund and the pension fund and the provident fund should be paid over and above section 53 priority. However, in this case, it has been corrected now. It is very clearly said that the payment of gratuity to employee depends on their entitlement of gratuity, subject to fulfillment the conditions laid down in the Payment of Gratuity Act 72, and also on the availability of funds in this regard. So what NCLT has held, that there is no fund in the balance sheet, so there is no priority over and above section 53. If gratuity is payable, if pension is payable, or even if provident fund is payable, those would be paid under section 53 and not above 53. Above 53 is only fund and not the dues. So there is a difference in funds and dues. So the dues would be everywhere. Fund would be only in those companies where the funds are being maintained and it is being invested in the company balance sheet, and that is earmarked for the purpose of provident fund, pension, or gratuity. So there was no such fund. So now the situation is completely reversed. As far as the provident fund, pension fund, and gratuity is concerned, all this workmen and employee dues will fall on a pari passu stand with the secured creditors. So this is a very important judgment I wanted to share with you. So the other part which is important in liquidation process is the claim by the other stakeholders. By the other stakeholders mean anyone who is not a financial creditor, operational creditor, workman, employee, or government authorities. They can also file their claim as a stakeholder. For example, For example, preference shares, equity shares, or any other dues from the company. And the document that we are supposed to, if this particular claim will be filed in Form G, and the document that we would attach is something like affidavit and the electronic, see, documentary or electronic evidence of shareholding, that also is very important, and that has to be attached along with the claim which is filed.
So some questions, some questions that there is more clarity required between difference between Form E and F. That's one. And the second question that seems to be relevant to the discussion at hand is that what will be the treatment to a labor contractor? Can he file as a workman, or will he file his claim as a contractor?
The labor contractor is not a workman. A workman, because the labor contractor is never a workman under the provident fund, the gratuity, or any other law, because those are only supposed to be the responsibility of the principal is only supposed to be for the ESI, and also to make sure that all those people are subject to provident fund and the contractor is complying with all the laws. The Form E and Form F, the difference between Form E and Form F is, like in case of numerous employees or workmen, there is a possibility that one authorized representative is filing the claims on behalf of the workmen, because it is at times difficult for the workmen to file the claim. So the company's own HR department, based on their own records, they normally file a statement which is a complete list of employees and workmen, and also along with this Form F, and all the workmen and employees, they appoint that person as an authorized representative. So if a standalone basis, Form E, collective basis, Form F. Any other, Ankit?
You can continue. Those were the two questions that were relevant to that page. That's why I interfered.
So now the verification of the claims by the liquidator is a very, very tough job, because the verification under the liquidation processes has to be a very detailed one. It has to be adjudication by the liquidator. In this case, the quasi-judicial officer has been considered. The liquidator has to pass an order for verification of the claims. So within 30 days, the liquidator has to verify all the claims, and that is from the date of the last date of submission of the claims. And the liquidator can reject, admit, part admit, or part reject. These are the powers with the liquidator. The liquidator can further ask for some documents, some evidences, some stories, some ledgers. Every other documents can be sought by the liquidator from the claimant. If there is any cost incurred by the claimant for visiting the liquidator's office, the liquidator is not supposed to pay, or any other information or any other cost incurred by the claimant for the verification, that has to be borne by the claimant and not the liquidator. However, any false claim, in case the liquidator come across a false claim, then the matter may be reported to IBBI, and the cost of that verification process also be recovered from the claimant. This is important, that we in case we have any false claim, so we can recover the cost from that person. So while we are trying to understand the various scenarios while verification of the claims, so I will actually take up these small subjects. So in case we have a contingent claim, the claim definitely would be filed. The claim would also be accepted. However, it will be collated also. However, when it comes to the actual distribution, and in case the assets are sold and these contingent claims are not crystallized, then that money would not be disturbed to the claimant till the time the claim is crystallized. So the contingent claim, it may be contingent on an event, it may be contingent in a court of law, contingent in any tribunal. So it is not really possible to adjudicate all these claims, and that may be under under different sections. So neither the NCLT nor the liquidator would have any power to say handle a claim from excise department where appeal is pending, handle a claim from custom department where an appeal is pending. Then maybe some property dispute claims are pending, maybe some claims are pending where the bank guarantees have been given. So all these kind of contingent claim, this is a very important that the liquidator should receive all these claims, and based on the best judgment, the liquidator will assess it and will include that name into the list of stakeholders. So in case there will be any claimant who is aggrieved from the assessment or the estimate of the claim made by the liquidator, the uh, claimant has a power to go to appeal under section 42 of the code, and that appeal will go to NCLT. So in case the debt is in foreign currency, then it has to be converted in the Indian currency based on the official rate of official exchange rate of the RBI. Now coming to another class of claims, there may be a possibility that I am receiving, the company is receiving, or any person is receiving some periodic payment from the company. Now, when I am receiving a periodic payment, that may be interest or that may be rent. So maybe that I have an agreement to stay in the property for 3 years, and also maybe there is a lease agreement which is for 3 years, and I'm paying a monthly installment. So wherever there is a periodic payment, we actually have to close that periodic payment and make a calculation up to the date of commencement of liquidation, and beyond that it would not be verified and admitted. Any periodic payment will be considered only up to the date of up to the liquidation commencement date. Debt payable at future date, as I will explain to you, that matured or unmatured, the same example was again can be again used in the case of deep discount bond, or in the case of any kind of debt which is due in a future date, that also has to be accepted. However, the distribution, whenever we are making distribution, then it will be a calculation based on zeal, which is given in the regulations. So as far as the admittance is concerned, and as far as the distribution is concerned, the distribution would be based on the yield, considering the total period of the debt. Mutual credits and set of, I would like to explain to you with some examples, that if party like the corporate debtor has an account with the ABC, and in one account ABC is a debit and other account ABC is credit. So then while filing the claim, they have a right to a set of both. They have a right to set of both, and then file a claim for the net amount. They have a right to set up both, but they have a right to claim for the both. Now, taking this example, we are also considering that we have given a loan, or we have given a car lease, and there is a deposit, there is a margin money which we have deposited with the bank. So in such cases, when the bank will file a claim, so the bank will file total claim minus the installments already paid. So both the things, and the other retention money or anything else which is as a margin money which is kept in a separate account, that would be net off before claim is filed. The claimant has also a right to withdraw the claim within 14 days of its submission. Separate claims to be filed for each type of credit. So the operational creditor will file separate, financial separate. So in case one person has got 3 claims, one, that I am an employee of the company; second, that I have supplied some goods to the company; third, that I have also given some loan to the company. So that particular person will file 3 claims, one for the operational credit, the other for the financial creditor, and the other for the workmen and employees. So this is very, very important to understand, that for each kind of claim, the separate form has to be filled. We consider the rejection of the claim by the liquidator and the rights of the claimant to appeal. As I said, whenever we verify a claim during liquidation, it has to be communicated. Once it is communicated, the information that should go with the communication is the amount admitted, the priority under section 53, that subclause, the category, whether it's secured or not secured, and the security interest. In case we are able to mention the security interest that you have, that also is possible. So the communication for admittance has to be signed by the liquidator, and it should go. The communication for admittance can be a kind of a certificate, or it can be a kind of letter. So that has to be given to each claimant. So in case of a rejection, Then the liquidator also to record the detailed reasons for the rejection. So in case a claim is received, the liquidator has to work hard for admitting or for rejecting that claim. In case the claim is not, the claim is rejected, then there are many orders which says the liquidator has to record reasons while rejecting a claim. And in case the claim is rejected without any reasons or without recording any reasons, then it may not be accepted as a rejection. So it's like in case we are very happy to get hold of a very recent judgment, which is 22nd of May 2020, Indian Oil Corporation Limited versus Ashish Arjun Kumar Rathi. And in this judgment, it was held that not assigning reasons, and that too in a rejection order relating to a claim, is not prudent and reasonable course of action. In respect of interest also, it was held that merely stated that as per the contractual agreement there was no provision for an interest, and hence the interest was not considered, is incorrect and legally untenable in the eyes of law. So the NCLAT is saying that the interest has to be given, and whenever there is a rejection of the claim, it has to be a spoken order, it has to be a detailed order. The liquidator can decide about a claim irrespective of the litigation. This is the case that I discussed in my case also. The liquidator can decide about a claim irrespective of the liquidation. Power Grid Corporation of India versus Deepak Cables India Limited. The pendency of a case before the High Court is not to come in the way of liquidator to decide the claim. As far as pendency of the arbitration proceedings is concerned, after liquidation, it is open to the arbitral tribunal to proceed in the arbitration. However, we are not inclined to express any opinion with regard to the same. We are of the view that the claim is filled by the corporate debtor, Deepak Cables India Limited. There is no bar to proceed in the arbitration, and if it proceeds, its counterclaim to be decided. If the counterclaim is awarded in favor of the appellant, and if the certain amount is payable to it, it can take advantage of the same. So it was made very clear. That with regard to the claim of the appellant, it may be decided by the appropriate authority arbitration proceeding. And it was said that it will not be decided by the NCLT, because the arbitration proceeding will have all these commercial things. Now we can come back to the very important part of liquidation, that is the verification of security interest and presumption of relinquishment. In fact, this should be presumption of relinquishment of security interest, which is given in Regulation 21 and 21A. The definition of secured creditor is only like anyone who is having a security interest. Definition of the security interest. In this, I only would like to highlight the couple of things. Right title is okay, and the basically what I want to highlight is the includes mortgage, charge, hypothecation, assignment, and encumbrance of any or any other agreement or arrangement securing payment or performance of any obligation of any person. So the performance of any obligation of any person is an important part of it. Otherwise, the security interest is all clear that in case we have any charge, we have any mortgage, hypothecation, assignment, encumbrance, all this is considered as a charge, as a mortgage. Now we are only talking about performance of any obligation, performance of any obligation. Suppose I enter into a home buyer enters into a contract with the builder, and the builder signs the builder buyer agreement, and the home allottee gives the money to builder. So based on this transaction, the builder has committed himself to perform an obligation of giving him flat, and the allottee has got a right of seeking performance of any obligation from the builder. So when we say that, I'm only trying to make a case here that even the allotment of flat, where the property is identified, where the builder buyer agreement is executed, the construction is already started, so that can be identified that this is the property. So there is a performance obligation on the builder, and that performance obligation will make that payment by the allottee or by the home buyer as as security interest. So this is the security interest part that I wanted to decide. And in case we read this, the created, like the charge is created by a transaction. Charge is created by a transaction. So the transaction is also there by includes an agreement or arrangement in writing for the transfer of assets or funds, goods or services from or to corporate debtor. So based on an agreement, there should be an obligation based on obligation. The transaction, when we say transaction, also we say that the performance of an obligation, even in this line, it is said performance on obligation. And when we say the by way of a transaction, so the transaction is include an agreement. So in this transaction also, the BBA agreement can be considered as a transaction. And transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer of right, title, possession, or lien, etc. So when we include the definition of transaction, transfer, security interest, secured creditor, I feel that the home buyer is a secured creditor. And even if we have to add the further definition, which is given in section 335, transfer of property means transfer of any property and includes a transfer of any interest in the property and creation of any charge upon such property. So when I enter into a builder buyer agreement, I mention the property number, flat number, description of the property, and we can physically identify that property in that manner based on the definition of security interest, secured creditor, transaction, transfer, and transfer of property. It is all given in section 3 of IBC. It becomes a case where the allottees, home buyers, can be said as secured creditor because the definition of security interest is very clear. See, while we are seeing so, there is only one hurdle to my interpretation. That hurdle is regulation 21 of liquidation process regulation, because the existence of a security interest may be proved. So the word may is written here, may be proved by a secured creditor on the basis of IU, certificate of registration of charge in before ROC, proof of registration of charge with CERSEI. So there are only 3 verifications given so far. So when there are 3 verifications given, then in that case, this is only may. So there can be any other security interest documents that can be considered for proving security interest. In these 3, it is only said that the existence of security interest may be proved by the secured creditor on the basis of IU, means that in case the evidence is there in IU, then there is no further evidence is required. Or if it is there in ROC, then also there is no further document required. Or if it is available in CERSEI, then again further document may not be required. However, in case these 3 documents are not there, based on some other document, the security interest can be proved. This security interest has to be proved based on these transaction definitions, based on the definition of security interest, based on the definition of transaction, based on the definition of transfer and the transfer of property. If we look into these definitions, 5 definitions, and then look into the documents which is submitted by the bank or any creditor, then we will be able to decide whether it is a security interest or not. Because this regulation 21 is only saying that you may look into these 3 things to avoid looking at any other thing. So this is the one part which is very important, and I wanted to convey that. We have also filed an application to bench in New Delhi, and one of the home buyer has filed an application where we are saying that the home buyer should be treated as a secured creditor, because as per the definition they are a secured creditor. So when they are competing with the secured financial creditors, so their interest can be further protected under IBC.
So one of the questions is that say a financial creditor has a claim of 800 lakhs and the security interest that is available is valued at only 10 lakhs. So how do you calculate secured and unsecured claims? So does the entire 800 lakhs become a secured claim? That is a question.
So this is a very, very important question. A very, very important question. See, like I think we also, this concept is a very new concept. In fact, uh, in the discussions, in the backward discussions of some NCLT also, there is a concept which is getting little popular, is that the secured creditor is only secured to the extent of the value of its security interest. So there is a concept which is which may be amended at any time of time, that out of the 800, 10 is the secured creditor and 790 is the unsecured financial creditor. This is what is the actual this is what is the actual meaning which some people are trying to give it. However, the difference would be only one: what we are doing presently. In case we are selling that asset of 10 crore, we are giving the 10 crore against this 800. So that means that the balance amount 790 is unsecured. So the balance assets would be sold and the balance assets would be given to those who have security interest on those assets. And then we will have a list of all those claims which are unsecured, having no security interest. Then if there is any amount which is recovered, or which is the sale proceeds of any of those assets which are not a secured asset, then that amount presently we are allocating to secured creditors only, but maybe a time will come that the secured creditor and the time will come when the unsecured part of the debt of secured creditor and unsecured financial creditor will stand pari passu, because this is a concept that if everything has to stay in the secured creditor's priority. So even if a person is uh, have given only a loan of 500 crores against a security of 1 crore, so the entire 500 crore will get a better priority, would be considered as secured creditor. So that's not something which actually is healthy for the credit market, because then there will be a race that even if there is a loan of 500 crore, everyone would like to make it secure for getting some better realization in the insolvency of that company. So, for the time being, my answer is that 10 is the security interest and balance 790 would be paid when the all the security interest would be over, and it would be basically paid out of the other assets in proportion to the unsecured part of the debt of other secured creditor for the time being. For the time will come when it actually will be collated with the unsecured financial creditor and the unsecured part of the secured financial creditor. They all will be pari passu. That's a discussion which is going on, and it is got a rationale also, that secured creditor is only to the extent of the security interest. And that's so because in case we see this latest amendment in section 30 subsection 4, where it is said that the resources under a resolution plan may be allocated to creditors based on their priority and value of security interest. Based on their priority and value of their security interest. So this is a very, very important question I wanted to answer. Any other, Ankit?
So basically, the question is from Lata Ragnathan. In real estate company under liquidation, how will the home buyers get the amount paid if entire assets like land is mortgaged to multiple bankers, financial creditors?
Maybe in the case of home buyers, it's like the most of the cases that we are handling is the cases where the resolution plans are expected and the resolution plans provide for the completion of the project. So what we are doing is that the first interest is to complete the project, get the property completed, hand over the possession, and then in case there is anything remaining after the sale of unsold inventory, that will be given to the secured creditors. So that's a part of the resolution plan. However, in case we go for liquidation, then the liquidation, again, it has to be tried as a going concern. And later on, instead of going concern, it actually can go to the, liquidating the assets of the company and then distribution. See, that distribution so far is not clear. And insofar in case we will go by that definition, then the secured financial creditor will have the right first, or the secured creditor will have the first right and then the home buyer. So that is the reason that none of the real estate companies are trying to go for liquidation, and they are all trying to see a resolution plan.
So there is another question which says, which is from Mr. Pankaj Sahu, which says whether differentiation is made between first charge, second charge, and residual charge holders among the secured creditors.
I'll just come to that in a couple of
so I think
slides.
then we can continue, and I think I've answered a few questions.
Okay, see, the amendment was done on 25th of July 2019, and the regulation 21A was introduced. And in this particular regulation, it was the difficulty to the liquidators were in fact completely erased. I have certain cases with me in the beginning of the liquidation process, where the secured creditors, they did not relinquish their security interest even for 6 months. I was not able to sell the assets, and they took the decision after 6 months of the liquidation order. But now they have to submit their form in Form C or Form D. They have to submit, and they also have to say that whether the security interest has been relinquished or not. So they mostly will say that yes, it is given, and in case they does not intimate its decision within 30 days from the liquidation commencement date, then the assets covered under the security interest shall be presumed to be part of the liquidation estate. So that's where it is important now, because while filing the form by any secured creditor, they are supposed to declare the relinquishment or not. So in case they don't do that, then it will be considered as already relinquished. So where a secured creditor proceeds to realize its security, it shall pay. I was referring to this regulation 37, and it was in response to a question which was asked by one of the participants today. In case the secured interest invokes section 52 and try to realize the security interest himself, then it shall pay CIRP cost on the liquidation cost, B, workman dues for the period of 24 months preceding the liquidation commencement date, to the liquidator within 90 days. To the liquidator within 90 days. And in case the value realized by the asset, in case the value, so actually there is another scenario, like the secured creditor will take the asset from the liquidator and will not be able to sell. The secured creditor, it was happening that the secured creditor had invoked section 52 and they were not able to sell, and the liquidator is just hanging in between, because the liquidator has to pay for the CIRP cost, liquidation cost, workman dues. So the two things that we have to claim from the person invoking section 52, one, CIRP cost, two, workman dues, and the third is any excess amount realized by that particular creditor. So in case the total security value is 10 crore and the total dues are only 8 crore, the 2 crore has to come back to liquidator. That has to come back. So in case, and that has to be done within 180 days. Now there is another scenario that the secured creditor is not able to sell the property after invocation of section 52. Then in that case, in case they are not able to sell within 180 days, then they have to make payment to liquidator. They have to make payment to liquidator, which would be the difference of the estimated price of the security interest and the total debt. And the difference has to be paid to the liquidator along with the CIRP cost, liquidation cost, and workman dues. So with this amendment, even if everyone invokes section 52, still the CIRP cost, liquidation cost, any excess in the value of the security interest has to be given to the liquidator. And that's what is section regulation 37. It is amended. That's very, very important. Now it comes to the question of the first charge and second charge and the subservient charge while we are allocating the resources or assets, proceeds of the assets to the stakeholders. Since there is no other judgment and the only thing that we have is section 30 subsection 4 that is applicable in the case of resolutions, However, we have seen this Insolvency Law Committee report, and which is dated 26th of March 2018, and we went through the paragraph number 21.1 to 21.6. So in these paragraphs, it has been clearly said. It has been clearly said in many words that the first charge, second charge, and any agreement between the creditors would be honored. So the first charge would have the first charge, and the second charge would have the second charge. Even it is referred there in this case of ICICI Bank Limited versus Sidco Leather Limited. It was a case under the Companies Act, and in this winding up or liquidation proceedings, it was very clear that the first charge, second charge concept, and that would be decided based on the priority of the charges between the secured creditors. Even Section 48 of the Transfer of Properties Act clearly provides that the claim of a first charge holder shall prevail over the claim of the second charge holder. And it is further said in the Insolvency Law Committee report, merely because the relevant section did not specifically provide for the rights of priorities over mortgaged assets, it would not mean that the provisions of Section 48 of the Transfer of Properties Act shall stand obliterated in relation to a company that has undergone liquidation. See, moreover, this may negatively impact the credit market. I will just give you an example. Now, suppose in case we start saying that the first charge, second charge, or the subservient charge would not be honored, and whatever is recovered during liquidation process, that would be distributed to all the secured creditors, irrespective of the value of their security interest. Then what happens? Now, suppose I'm a liquidator, and there is a car which is financed. The market value of the car is on 20 lakhs, and the debt outstanding is 15 lakhs. So if I sell the car, I give him 15 lakhs, and balance 5 lakhs I retain myself. In case the bank invoke Section 52, he should also get the entire amount, and he should pay back the amount to me. So one scenario is that this is a correct position. Now the other scenario is that if I sell the car and try to allocate and the total sale of asset proceeds to all the secured creditors, then the car lender will not get any money, because there are other people who have financed working capital and their security interest value is very less, and there may be some other people who have actually financed assets and their security interest value is high. So the committee has concluded very clearly. To conclude, the committee was of the opinion that it is sufficiently clear from the plain reading of Section 53(1)(b) that it intended to rank workmen dues equally with the debt owed to the secured creditors who have relinquished their security interest. The Section 53(1)(b) does not talk about priority inter se secured creditors. Thus, valid inter-creditor subordination agreement would continue to govern their relationship. So it was basically a concluded part of the report that the first charge, second charge, any subservient charge, any inter-creditor agreement, any subordination provisions would be honored, respected in the liquidation waterfall arrangement. So now this is a part where we actually have said that the verification of claim, relinquishment of the claim, and the security interest, what is secured, what is unsecured, to what extent it is secured, to what extent it is unsecured. That's all we have seen. And based on all this, we would prepare a list of stakeholders under Regulation 31. And the list of stakeholders will have some information which is provided in Regulation 31. And this list of stakeholders shall be filed with the adjudicating authority within 45 days from the date of receipt of claims. That means first 5 days public announcement, 30 days in receipt of, and then next 30 days in verification, and next 15 days for the report. So that means it is basically the 80th day from the LCD, liquidation commencement date. The list of stakeholders has to be submitted to adjudicating authority, and along with this submission, it also has to be appearing in newspapers, like one in English and one in regional, having wide circulation. Now, this was a question which was asked by someone, like in case after the list of stakeholders is made, after it is submitted to the adjudicating authority, in case liquidator gets further claim, what is the process procedure? So in case liquidator gets further claims and the liquidator also find the reasons for not submission of the claims earlier, then liquidator would prepare a modified list with an entry into the list of stakeholder, and that particular entry would be modified and based on the additional information, and that has to be then an application has to be made, and then an application has to be made to the adjudicating authority for modification in the list of creditors. Uh, the list of the list of stakeholders as modified from time to time shall be available for inspection by person who submitted proof of claims, available for inspection by members, partners, directors, and grunters of the corporate debtor, and it should be displayed on the website of the corporate debtor. This is what is the kind of we finished that part, which is the claims, verification of the claims, verification of security interest, and also kind of touch base with the other part, which is the all this regarding the claims and liquidators' powers and appointment. And now, Ankit, we are reaching to the stakeholders consultation committee. Since we have Mr. Anil Agarwal with us today, who is a senior partner at Kolkata. So till this time, Anil ji, you have a lot of experience in verification of claims. And what are the difficulties that you are facing in practically verification of the claims or getting the information from the corporate debtor? So this is the only part of the verification of the claims security interest. So what exactly, can you share some of your experiences?
Yeah, good afternoon, everyone. While verification of claim, the main difficulty which we face is the documents of the CD or the records of the CD. The records of the CD are mostly not available immediately after the takeover of the company. If we are a RP, then we have control over the assets and documents of the company. Say, for example, we were not the RP, and we took charge from the other RP as liquidator. Then, when liquidation officer, the employee is discharged from their liability, they उनको हटा देते हैं. And the promoter is also non-cooperating in nature, because they are not bound to provide ye. So within 75 days, verification of claim is very difficult task. Within 30 days of receipt of claim, it is a difficult task. The records are not available. The main thing is the documents provided by the claimant are not sufficient, and we cannot verify those documents with the CD records.
Okay, so you find that there are difficulties with regard to the information which is provided by the corporate debtor or their employees or the ex-directors. I also have these difficulties, but once the company goes into liquidation, the directors, the key managerial personnel, they lose interest in the company, and even none of the employees interested in continuing with the company, and the information flow becomes very difficult. So in the process, some of the assets of the company even doesn't come to the knowledge of the liquidator. That's a big loss because the information stops coming. So even if we file application to NCLT, you see NCLT was experiencing a big overload of work. So they were not able to give us much attention to the applications under section 19.2 or under section 35. So all those, these cases also, it was difficult for getting any relief. And there are other many practical difficulties that we will come and discuss in this webinar. So Ankit, is there anything else that we have any important question? And
So one of the questions is that how is the representative of a category of stakeholders finalized?
I'm coming to
And
this
I think
because
we will talk about this in the coming year.
this part is only about stakeholders consultation committee,
exactly.
which is section 35.2 and regulation 8. Because the 35.2 provided only one liner that the liquidator can consult the stakeholders. Then regulation 8 also said the same thing. However, in the like there was an amendment again on 25th of July 2019, and when the stakeholders consultation committee concept was introduced in the liquidation process. So the definition of the consultation committee means the stakeholders consultation committee constituted under sub-regulation 1 of the regulation 31A. So a full regulation like it's a 31A was introduced, and the liquidator was made responsible for constituting a stakeholders consultation committee within 60 days from the liquidation commencement date. Then like let's understand who would be the members of the stakeholders. We can call them representatives. So it's not a member, it's a representative. Only those who, first of all, only those members can become, only those persons can become member who have relinquished their security interest in favor of the liquidator. And it is the duty of the liquidator to facilitate the stakeholders of each class to nominate their representatives. Like for example, workmen, for example, operational creditor. It is the duty of the liquidator to facilitate. But in case they are not able to do that, see, first of all, the workman employee, they have to try themselves. The operational creditor, they have to try themselves. In case they are not able to do that, then the liquidator will make an effort to facilitate their nomination. So this is the kind of scenario for the present constitution of stakeholders consultation committee. In short, I will say SCC. So out of the secured financial creditors, we have maximum 4 seats. 4 representatives can be taken. In case the claims are less than 50% of the liquidation value, then 2. And in case the claims are more than at least 50% of the liquidation value, then 4. Similarly, for unsecured financial creditors, everything is corresponding to the liquidation value. The figure is 25% in this case, either 2 or 1. In case it is 25% or above, it is 2, otherwise 1. One seat has been given to workmen and employees, 1 to the government authorities, and similarly 1 and 2 has been given to the operational creditors other than workmen and employees. Then 1 has been given to shareholders. So the total there are 11 seats, maximum 11 seats, 4, 2, 6, 7, 8, and 3, 11. Maximum SCC can have 11 seats. And the SCC, what is SCC now and how the meetings takes place? The meeting can be called by the liquidator whenever he feels necessary. Even SCC can also request for a meeting where at least 50% of the representatives have to ask the liquidator to have a meeting. Liquidator will chair the meeting, and recommendations of the COC under regulation 39C of the CIRP shall be placed before SCC on its formation. And that's regarding the 39C regulation of CIRP is regarding the assessment of sale as a going concern. Assessment of a sale as a going concern. So that decision of committee of creditors has to be placed before the SCC regarding the assessment of sale as a going concern. The liquidator shall maintain the particulars of any consultation. There is a form A in schedule 2 prescribed for the records of consultation. And when we go to the various reports which are supposed to be made by the liquidator, even the minutes of the meeting of the stakeholder is also considered to be as one of the record. So this record is also required to be maintained. This record is also required to be maintained, and the minutes are circulated. And these records are called minutes. So when we say the reports which are supposed to be filed with the adjudicating authority, and so this is also one of the report which is supposed to be filed with the adjudicating authority, and practically it is being filed along with the progress reports. So in case during a quarter in case we have one SCC meeting, So in that progress report, we can also attach the minutes of that SCC meeting in that quarterly progress report. Now, let us understand what are the powers of the stakeholders consultation committee. One, the role is very, very limited, very limited role. The role is to advise the liquidator on the matters relating to sale under Regulation 2. Relating to sale under Regulation 2 and the Regulation 32, that actually is only restricted to the manner of sale, which is the slump sale, piecemeal, business as a going concern, as a group of assets, and the company as a going concern. The SCC is supposed to be advising the liquidator only relating to the matter of sale under Regulation 32, not even 33, not even 34, not even Schedule 1, because see, the Schedule 1 is not under Section 32. That means the fixation of reserve price is not the role of the SCC. The deciding about these sales to go or sales not to go is not a part of the SCC matters. It is only to decide whether the company should sell the assets on piecemeal, on a slump sale, group of assets, business as a going concern, or a company as a going concern. See, for this reason, for the purpose of deciding the manner of sale, the SCC shall have the access to all relevant records and information as may be required to provide the advice. SCC shall advise the liquidator by a vote of not less than 66%. So in this case, his vote is not based on the total debt. While in CIRP, the COC has a voting power based on the amount of debt. However, in the case of SCC, the vote is only based on the total number of persons, number of representatives present and voting. So in case there are 11 people there, and in case they have to vote, and 11 people, they voted in a resolution, and let us understand that in case there are 11 people and they have to 11 into 66, so 7.26. So 7 people voting, 7.26 means 8 people voting in favor of in favor of one advice. That would be considered as advice of the SCC. So even if 66% and rounded down or rounding up, I think that is possible. So maybe 7 is the total number of persons who should be present and voting for one advice of the SCC. And again, like it is very clearly mentioned that the advice of the consultation committee is not binding on the liquidator. In case the liquidator is not ready to accept the advice of the SCC, then the liquidator has to place on record the reasons for not agreeing to SCC. And it is also mentioned that the stakeholders who are consulting the liquidator shall extend all the advice. And now this is the matter of, these are the matters relating to Regulation 32, which I said the Regulation 32 only talks about the assets on a standalone basis, slump sale, collectively, parcels, business going concern, and a company as a going concern. Even Schedule 1 is under Regulation 33. This is what I already discussed, and not under Regulation 32. Therefore, the process of sale as defined under Schedule 1 would also not fall under the role of SCC. Marketing strategy, fixation of reserve price, auction process, private sale, etc., all are part of Regulation 33, so does not find a place in the role of SCC. However, the practice amongst the professionals, practice amongst us is to consult on most of the actions. As a matter of transparency, we are actually consulting on most of the things to the SCC. See, we have finished that chapter again. Ankit, can we take some questions again? Then I will shift to liquidation cost.
Yeah, I have a few questions. One of the questions is from Mr. Vikram Singh, also from Mr. Abhinav Garg. What I will do is I will simply try and unmute them. Maybe they can ask the questions in person. So I think I am just trying to explore how to unmute him. Give me a second. Vikramji, can you raise your hand?
I think you can read, otherwise the time is already little strained.
So I will, yes, I will do that only then. So he says that basically, he says that this is concerning some liquidation cost, and he says that we have not got our liquidation cost approved from COC under Regulation 39B. So as per regulation of COC did not approve liquidation cost under Regulation 39B, then Regulation 2A of liquidation process will apply, which states that the financial creditors will have to contribute excess of liquidation cost over liquid assets. Liquid assets have not been prescribed anywhere in the code and regulation. So what would be considered as liquidation assets while arriving at the calculation?
I'm coming to this part of the presentation only. I
Then,
don't think this question, it will automatically be answered in the next 5 minutes.
then I have Mr. Abhinav Garg asking that I am a creditor of a company. It has been established in the transaction audit report and in the hearing in a matter of NCLT that the CD has conducted the business just to defraud its creditors. Despite this, whether waterfall mechanism will still be applicable under the liquidation process. Then he also has a question that, as above in the case, can't the liquidator lodge an FIR for cheating against the promoters, directors, KMPs, etc.?
No, I think this is a different question. This is different than
Yeah.
the liquidation process. We should actually restrict to the liquidation process questions today. And definitely my next target subject would be the avoidable transactions and the transaction audit and the forensic audit. I think that's the next question, which is dear to my heart. And I know that there are a lot of questions about this. So I would be preparing. So I would not like to answer this question now because this is not even related to. However, I can simply say that there is no power that we can file an FIR against the promoters. The only thing that we can do is whenever there is a complete evidences, then we can file file an application to IBBI's prosecution department. IBBI's prosecution department will take up this matter, and we have to cover it up under section 68 to 77. Any of these sections may be applicable on these offenses, and then the IBBI will start the prosecution, not the RP. RP does not have any power under IBC to file any FIR unless it is a offense which is not under IBC, maybe for a theft, maybe for any other untoward incident at the corporate debtor. Then RP has all the powers, whichever and whatever is normally used by the board of directors. But as far as the under IBC, in case we have to consider anything as fraud, and those powers are only with the IBBI under IBC. Nobody else can prosecute any person.
I think we can come back to the topic. So one topic is that is there any concept of e-voting in case of liquidation?
No, there is no concept of e-voting in the case of liquidation because there are only 11 members, 11 representatives, and 11 representatives can always physical file. And this is also not e-voting because they have to be physically present and voting. So physically present and voting, because the concept is very clear, they have to be present and voting for any suggestion that they are giving to liquidator. There is no concept of e-voting.
Next question is, should liquidators send the stakeholders consultancy committee proceedings report to those stakeholders who have not attended the meeting?
Yes, there is a regulation about it that whatever you consult to even one stakeholders, the information of that consultation should go to all the stakeholders.
Then there's a question on valuation report. Can the valuation report be shared with the members of SEC?
The valuation report has to be shared with the members of SEC because they have to decide about 32. Regulation 32 has to be, because it is their basic role to decide whether the company, the assets of the company should be sold in what manner and in which manner. So that is the basic role. So they have to get the valuation report. Even otherwise during liquidation process, and there is no secrecy about the valuation report from the members.
Okay, then there's a question, can a liquidator directly sell assets on a private contract or he has to go through public auction? I think you're yet to...
No, the liquidator can also sell the assets through a private treaty. and it is not always mandatory that the liquidator should go ahead with the e-auction.
Whether stakeholders committee meeting minutes are sent to other financial creditors also who are not represented on the SCC.
For the purpose of transparency, we are sending it to all these creditors. In fact, what we are doing is that we are making as far as the representatives are concerned, for the purpose of voting, the representatives will be only restricted to 11. However, all other financial creditors, secured financial creditors, we are making them as invitees to the meetings, and they are also providing their input, and we are trying to share with them the efforts done by us. So in fact, the very important part during the liquidation process is how to assure the transparency in the process and how to make the stakeholders feel comfortable. Because see, this is the first time in the history that this much power has been given to a private professional. So we are handling companies which are having assets worth 1,000 crore, and the stakeholders have invested maybe 10,000 crores in those companies, and they are now looking at that 1,000 crores and how somebody is handling this 1,000 crore and how this will be sold and when it will be sold and what actions and what efforts that are being made. So this is something which is very, very important, that we all liquidators should try to give comfort to the secured creditors, because unless they find comfortable, they would never relinquish their interest into the liquidation estate of the corporate debtor. It is very important that we should give comfort to them. So how can we give comfort to them? I will come on to my next slide. So there are many things that is not provided in regulation 2032A for the stakeholders consultation committee, which we are doing, and we are doing only for the sake of maintaining transparency in the process, and that is very, very important. All the liquidators should do that, so that the profession of liquidation, the profession of liquidator should be respected. Everyone otherwise would actually have complete apprehensions. They would not have any information what is being done by the liquidator, how many leads are coming, how the leads are being handled, whether the negotiations are being done properly or not. So all these apprehensions will lead to a trust deficit, and whenever there is a trust deficit, then they would not feel comfortable. Although the SCC doesn't have any power, but still what we are trying to say is that we are a service provider and we should remain a service provider. We should not become the liquidator as an officer. We are an officer, we are a respectable officer, but that we are working for someone. We are collecting money, we are realizing assets, and we are recovering money from the current assets, and we are giving it to them after charging our fee. It's a profession. We are working for someone. In fact,
I would say that the official liquidator earned a very, very bad name over the years because of the huge delays in the liquidation process. So I think we have been given a chance to do a better job. That is what we are here to do. So maybe you can continue with your presentation. And
so this is again a very big range of questions will be settled with this part of the presentation, which is liquidation cost and the contribution to the liquidation cost. So the liquidation cost has been defined, and a couple of amendments which has been done in the past 1 year that I can only highlight. Then the liquidator fee is a part of the liquidation cost. Professionals appointed is a part of the liquidation cost. Any amount spent on the verification of the claims, any amount spent on the preservation, protection of the assets of the company, any cost incurred for running the business of the company as a going concern, any interim finance along with the interest, any amount payable to the contributories, repayable to contributories under Regulation 2A, that all Regulation 2A is where the contribution is made by the financial institution and the bank, and any amount repaid to them, that also will become the liquidation cost. And any amount where the liquidator fee is essential, because everything is included in the liquidation cost. See, then there are some other regulations that we actually have collated, and we have found that the liquidation cost is also provided in various other regulations. So in fact, why we are supposed to do this is, like, whenever there is a resolution plan being approved by the committee of creditors, or there is a liquidation application which is being approved by the committee of creditors, it is also required that under Regulation 39B, we are supposed to provide the liquidation cost to the adjudicating authority, and also a plan, how the same would be contributed. So based on that, we actually have prepared a complete format where the liquidation cost can be estimated, and cost incurred by the liquidator in relation to a scheme under Section 230 would not form part of the liquidation cost. Public announcement cost, public announcement for list of stakeholders, watch and ward, security guards, professional fee for the maintenance of books of accounts, registers, fee payable to registered valuers, auditors for the filing of TDS returns, GST returns, expenses of meetings of stakeholders, e-auction, sale notice, publication charges, advertisement and publicity of sale of assets, cost of preservation. Last but not the least is that we are supposed to keep the records, books, minutes, registers for 8 years after the dissolution of the company, which is mandated by regulation 5.2 and 6.2. So we actually have to keep that money with the liquidator so that we are able to place all these records to an outside agency, and that cost also has to be built up in the liquidation cost. The COC under regulation 39B is under obligation to prepare a liquidation cost estimate along with the help of resolution professional, and they have to prepare a best estimate of the liquidation cost, also best estimate of the liquid assets of the company. Now the liquid assets of the company is primarily the bank account and not anything else, or in case there are any mutual funds which are easily sellable, or in case there are any FDRs which are easily sellable, those are the liquid assets, although it is not defined, but the liquid assets which can be liquidated at the option of liquidator, and that is what is the liquid asset. So liquidation cost minus liquid assets, that would be considered as the amount required to be contributed under regulation 2A. So this amount would be, there would be a plan that who would contribute this, and as everyone may know that the contribution has to come only from the banks and financial institutions, and it is not supposed to come from the other financial or operational creditors. So that plan would be submitted to the adjudicating authority along with the application for approval of resolution plan, or along with the application for liquidating the company. So the contribution, which is regulation 2A, again effective from 25th of July 2019, that has to come after the liquidation order is passed within 7 days to the liquidator. So in case the COC did not approve a plan for estimated liquidation cost, they did not approve a plan for estimated value of liquid assets and the contribution, then the liquidator shall call upon the financial creditor, being financial institution, to contribute the excess over the liquid assets as estimated by the liquidator in proportion to their financial debt, and the funds required need to be contributed by the non-financial institutions. So the regulation 2A, in case it is not done by the COC, then it has to be done by the liquidator, and the liquidator will call upon the creditors to contribute that amount, and then whatever is contributed, that also will carry interest at bank rate, which is presently at 4.25%. Okay, now coming to the liquidator's fee. Liquidator fee, first of all, the liquidator fee would be decided by COC under regulation 39D of the CIRP regulations. So that means the power to appoint a liquidator comes to COC, because the COC has to decide the fee. So the COC has to decide the fee of the liquidator in case of any scheme under section 230 of the Companies Act. In case the COC decides that the company would be kept as a going concern, then also the COC has to decide the fee of the liquidator, and for the balance period also it has to be decided as the fee of the liquidator. Okay, when the COC has not decided any fee, the liquidator will be entitled to the fee as per the chart. And in case the liquidator has not decided any, in case the COC has not decided any fee for the period under section 230, then also the liquidator will be entitled to the fee which was being charged by RP, The liquidator will be entitled to a fee as decided by the SCC for the period of keeping the company as a going concern. SCC will decide if the company needs to be kept as a going concern or not, because that part is not mentioned in the regulation 39D. It is mentioned, but in regulation 2A it is not mentioned. So we find that the SEC will decide the fee of the liquidator for keeping the company as a going concern. Then for the rest of the period, there is a percentage of the chart based on the amount realized and based on the amount distributed. And the first row talks about if distribution or realization is done within 6 months, then is the next 6 months, and then thereafter. So this was also amended on with effect from 25th of July 2019. Earlier there used to be 4 columns, and that one column was deleted, and that also is considered as a reduction in the fee of the liquidator. In case the amount is realized from the sale of assets or recovered from the current assets and is not distributed, then only 50% of the amount can be claimed by the liquidator, and the balance 50% will be claimed at the time of distribution. Both the charts are applicable, like the first chart which is on realization and the second chart which is on distribution. Both the charts are applicable for the fee. This one has been clarified by IBBI to us in one of our case on a letter written to IBBI, because the stakeholders were saying that only one is applicable, not both. So we got a clarification from IBBI that both the charts, like distribution and the realization, both are applicable. So we also have to see one thing, like in case we see the section regulation 2(1)(k) and the definition of stakeholders mean the stakeholders entitled to distribution of proceeds under section 53. So whenever we are distributing, so the liquidation cost and the CIRP will also be considered as distribution. Liquidation cost and the CIRP cost, in case distributed, that will also be considered as distribution, and the fee of distribution will be charged. So what I'm trying to say is that the liquidator fee, and there is a distribution fee also can be charged on the liquidator fee, which is distributed as per section 53. So according to this, the liquidator fee, if there is any question on the liquidator fee, we can even answer those questions.
So one question is that can the liquidator claim the expenses on traveling as liquidation cost?
Absolutely, because the traveling for the purpose of liquidating the company, maybe for inspecting the assets, maybe for having meetings with the prospective buyers, maybe for having any other SEC meeting, any kind of traveling is allowed. You actually have to see whether it is pertaining to the liquidation only or not.
Then there's a question that what if the FC decides a token fee of rupees 1 lakh for the entire liquidation?
No, whatever is decided by the financial creditor,
yeah,
if it is accepted by the liquidator, then nobody can challenge that.
Exactly. So then we have yeah, fee situations were those. Then we have a question that whether liquidator has a power to pass an order on the charge position. This is a question from Mr. DM Misra from PNB. And I think this question is already answered, that we as a liquidator, we can of course adjudicate. Or
now this is a good question, Ankit ji. This is a good question. Let me clarify once again. Unlike CIRP, during liquidation process, the liquidator is supposed to communicate admittance of the claim or rejection of the claim, or part rejection or part admittance of the claim. So when the communication is done with the claimant, what is supposed to be told to the claimant? One, the amount admitted, the priority of the charge under section 53, the category, whether it is secured or unsecured, and the security interest. So all these things are supposed to be communicated, because like I understand the amount, I understand the priority, I understand the security, and I also understand the security interest. So all these 4 important things are there, and in case there is any deficiency in the document, that also should be told to them. So in case the deficiency is not completed within 7-10 days, then the admittance would be cancelled. So this kind of communication is sent. So it is also it is very important that we have already seen there are orders NCLT has held in multiple times, that if the liquidator is rejecting a claim, it has to be a spoken and reasoned order. The liquidator is considered to be adjudicating the claim. So the liquidator has to pass a a very spoken and a good order, giving all the reasons for rejection. And then the other party has a right to go for appeal against the order of the liquidator under section 42 of the IBC. So this is a complete process. I find liquidation process is much more difficult than the process of CIRP, because this is one, that it is completely independent, and two, that it actually is. I'll come to other slides of my presentation, and I would like to handle few questions today, and then I would like to move on to my part 2, which will be again the next Sunday at the same time. Because see, the liquidation process is a very long process. It is not possible that we should be able to finish in 2.5 hours. And I don't want to leave anything which I'm not sharing with you, including practical experiences, which is not yet seen. It is only like theoretical part is going on, but then the practically, in case a lot of things that we are experiencing, that we are sharing with you in the subsequent part. And a lot of latest judgments are also being shared with you in the subsequent part. So anyone who is actually interested in the liquidation process must come for part 2 also, while I'm taking few questions, because I would actually be continuing for another 9 minutes, because 2.5 hours is the most, otherwise people will actually get bored. 9 minutes,
Then,
Ankit, if some questions can be answered by Mr. Anil Agarwal, our senior partner at Kolkata.
so there's a question coming in from Mr. Pankaj Sahu, that how do you calculate the distribution fee on the distribution amount payable to the liquidator? Can you explain a little further, because it is both in the numerator as well as in the denominator?
Yes, I think the way we have to calculate is again by the test and error method, and we have to just come closer, and we have to come to the rounding figure, because whatever we are distributing, including the liquidator's fee, that also has to be considered as distribution, because section 53 also includes CIRP cost and liquidation cost. The way you are thinking is absolutely right, only the test and error method.
Sir, one question is there.
We have
Chulmale, interim finance interest payable only for 12 months. What if the liquidation doesn't end till then? The lender are at loss for future interest.
I think this is a good question, because there are two things which are difficult presently. One is the contribution is supposed to be interest bearing, and the interest bearing also at the bank rate. The bank rate is presently 4.25%. So the contributors who are the contributories, they are only getting an interest of 4.25%, and that too they would be getting for the entire period. However, for the interim finance, although it is only for 12 months, what is the apprehension why this particular law was made? How can the law be made? How can the law be made when the total liquidation process is considered to be 1 year, and the law was made only the interest can also be paid for 1 year? See, what I feel, when this in any case of such where the assets are not sold, where none of the contribution or none of the interim finance has been paid back, and 1 year is lapsed, then an application can be filed to NCLT while we are extending the liquidation period after 1 year. Along with that application, we should also make a request that the interest be payable to the interim lenders, as they are why should they suffer because of these eventualities which has happened in this case, and the lenders are not getting their interest. So that should be allowed, because the NCLT will always consider that this interest also has to be paid in case the money has been borrowed from outside.
So then there are questions on creditors. So creditors during the CIRP period. So
I've lost your voice.
Yeah.
So creditors who have become creditors during the CIRP process, creditors who have become creditors during the liquidation commencement process. If liquidation is, if the company is in going concern during liquidation, what happens to the payments that are being made during that period? These are some of the questions.
Any liability, it's a very important question. Any liability which is incurred by RP during CIRP, any liability which is incurred by the RP during CIRP has to be paid in full as a CIRP cost. Any liability which has been incurred by the liquidator during liquidation process has to be paid in full as liquidation cost. and there is no possibility of any claim which can be filed. However, in case there is anything which is left unpaid, the liability which is incurred during CIRP and is left unpaid, then that person will file a claim to the liquidator, and liquidator will actually allot them a priority of liquidation cost, which is the top priority.
Okay, so next question is from Mr. Abhay Manudhane. He's asking that with respect to liquidator fees, you mentioned that you got clarification from IBBI relating to both fees chargeable by liquidator for realization and distribution. To clarify, suppose a liquidator crores, they can charge 5% on realization and 2.5% on distribution. Both
Absolutely.
The fees are chargeable.
Absolutely. In case it is distributed. In case it is not distributed, then not.
Then that 2.5% will decrease based on the distribution chart.
Yes, yes, yeah. So the realization timing and the distribution timing can be different. So whatever is the timing, that would be applicable for both charts separately.
LG, any questions that you can observe that we can take up right now?
I could see there are questions. I think there are
Mr. Rakesh Singhania, Mr. Rakesh Singhalla.
There are 230 questions that I can see.
Yes. So Mr. Rakesh Singhalla is asking that, dear sir, I wish to know what is the case I have been, that in case I have been appointed as liquidator from CIRP, where I was RP and company is going concern. So I think I've already answered this. My bad. So there is a question that what if the assets are unsellable? What to do?
No, I think in case the assets are unsellable, then there is a system that either you dispose of those assets, you convert that into scrap, and then you have to close the company, dissolve the company. Unsellable means like if it is not sellable at any price, then you have to just there is a separate section where you have to deal with these kind of assets. And based on those, there's only one section which has to deal with the, I'm forgetting the name of that asset, the name of these kind of assets. And then you have to dissolve the company.
We have a question from Mr. Ajay Jain that if liquidated estate is insufficient to even meet the CIRP cost, the RP's fee incurred by the RP, then how RP will recover his fee cost as RP was replaced by the liquidator?
The liquidator was replaced, the RP was replaced by the liquidator. See, I am very clear that once the liquidator is appointed, and who is other than the RP, then whatever will come first, that will be given to the liquidator. Or I'm not sure whether it will be considered as proportionate to RP and the liquidator. I'm not sure about that. But there is no other way that we have been able to find so far. We have also been talking to IBBI. Like there are many companies which are being allocated to the professionals like us by NCLT. And when the company comes to us, we find there is no asset in that, and there is no possibility of recovering your fee. And the creditors are also not responding, and they have withdrawn their claims. After looking into this scenario, they have withdrawn their claims. Looking into all this, there is no scenario so far, so that may be considered as a loss. So don't invest in these companies much, and you would be protected. And there is no need to incur further liabilities on you, because in case you find that the company is not having any asset, then whatever possible, you can make application yourself. You can appear before the NCLT yourself, and that is the way that you can handle it, so that there is no much cost incurred by you, because I'm sure there is no way that you can recover this amount anytime. No way.
And I think so people want to understand about the moratorium that has been put on IBC. I think that's again a very, very whole new topic. And
no, there is no suspension. I mean, I think you're talking about the suspension or moratorium of 1 year.
Yes.
No, so I think I will just try to recall. I would just like to everyone to recall yourself what statement was made by the Finance Minister, Honorable Finance Minister. The statement was that the IBC would be suspended for 1 year, up to 1 year. First of all, it was up to 1 year, so they may even change in between. Secondly, the definition of default would be given, and default which is COVID related default, only those cases would be suspended. So the power has been, like in the proposed ordinance, the definition of default would be provided by the central government from time to time. So whenever we talk about central government, that means the Ministry of Corporate Affairs. So the way it has been done in the past, by just one notification, that 1 lakh rupees was increased to 1 crore just by in 1 day. Similarly, whenever the government will feel that the hotel industry is suffering because of the COVID-19, or even the restaurant industry is suffering because of the COVID-19, so they can even define the default, which can be industry specific, which can be timing specific. I am 100% sure that the government will never apply this suspension to old defaults. Now, see, I will give you an illustration. Like, suppose the State Bank of India is sitting with an NPA. You see, even as per the data information that are available with us, there are about 8 lakhs crores of NPAs still outstanding in the books of banks. All those may not be entitled to insolvency because those may be proprietorship or partnerships or HUF or concerns. See, like, think of a situation that out of those, there are 2 lakh crores is still those which are companies or LLPs. So in case we say that it will be suspended, that means that there is no possibility of recovering that 2 lakh crore from the promoters who were in default even 2 years back. So that's not the intention. That has never been the intention of the legislature, the government, while announcing this. All those cases of 2 lakhs or 3 lakhs, whatsoever is presently pending with the banks, they have no other option except to go for either SARFAESI or to go for IBC. There is no third option. The third option of restructuring would be possible only those defaults which are happening because of this COVID-19, only because of the lockdown. Otherwise, the suspension is not something that you should be worried about. In any case, like in the current default, you may see the impact a little later, not now. Immediately after this, the lockdown will open, you will see many cases. In fact, in the AAA insolvency, in the last 10 days, we have received 3 orders for fresh CIRP. 3 orders that we have received for fresh CIRP in the last 10 days. So it is not something that you would be having no cases. It is only the way you market yourself. There are cases, there will be cases, and the insolvency and SARFAESI is going to be the only 2 options available with the banks for handling defaults.
That's great. So one last question I think we can take, and that question is with respect to notice of discharge for the employees. And so basically the question is that, does that mean that we should go for a separate discharge letter, or mere display of notice is sufficient? Or whether that discharge is effective from the date of liquidation or 90 days from the date of liquidation?
No, it is from the date of liquidation. And secondly, in case we can take the information about the employees, and a separate letter should be given to everyone, so that they should not tell later that they were not able to file their claims in case there is any pending dues. So just by public notice, it's like public notice is not provided in such cases. The notice at the gate or at the notice board of the company may or may not be seen for closed companies. So in case the company's HR department can give you the list of employees and also their contact numbers, it is important, it is rather suggested that we should actually write to them, or we should send SMS to them so that they file their claim if there is any.
Okay, so in case of a going concern liquidation, can the liquidator keep paying the active outstanding amounts that are due for keeping the company as a going concern? That is one of the questions.
Certainly, like even for, like, see, what I am saying is that during the CIRP, when we receive claims as on the date of commencement of CIRP, and then we start, and the company is continuing, and there are many people, they are current suppliers, and they are also continuously supplying. So whatever they are supplying, they are also getting paid. So the only thing that we actually have to make sure that the claim, whatever they have filed as on the CIRP date, that should not go up. That should, see, like in case it is going up, that has to be paid. But to the extent of the claim, that outstanding should always be maintained. Because in case somebody files a claim of 1 crore, and you are continuously buying and making payment to them, and that 1 crore gets reduced to 50 lakhs, that actually will show that you have paid 50 lakhs of rupees to one person, which will become a preferential transaction because you have not paid to others. So you have paid to one person 50 lakhs of rupees. The claim was 1 lakh, 1 crore. Now the claim is only 50 lakhs. So that actually would be considered as not the violation of provisions. The claims cannot be paid. Only thing is that whatever you incur during CIRP, that has to be paid.
So I think we have tried to take in as many questions as possible, and I think we will then talk about. We will share the YouTube recording of this session. This was also on Facebook, so we will see in case that has been recorded on Facebook, and we will share that link as well. And we will also communicate with all our participants the link to the next part to this liquidation webinar.
So Anil Agarwal ji, you would like to say something to the participants?
I think Anil is muted.
Okay, he is also like not showing his camera.
Maybe there's a network issue.
There's a network issue was there. So I think I would convey my thanks to each and every participant, and let me even say, even at the sake of repetition, the questions that you ask from us, that is actually giving pleasure to us. And I repeat that one question asked by one person, the answer goes to all the 700, 800 people who are listening. And in case we are not able to answer any question, like one question today I found, what is the name of that kind of asset which we are not able to sell? I will update myself to evening. So this is my way of learning. So whatever we are doing it only for our own learning, and there is no other objective. So we are enjoying this part of sharing our knowledge and sharing our experience, and in the process we are also learning. Thank you very much for participating and staying connected with us for 2.5 hours, which I believe is very difficult. And you have done it. That shows the content, that shows the value that you give it to us. And we are really grateful to all the participants. Thank you very much.
Thank you, everyone. Thank you.